Good morning, everyone. Thank you for joining us on today's webinar, Supporting Clients Through Divorce. I might just leave it for another minute just to let people get on because they're progressively getting on. I see the numbers popping up. And I hope you all have your cup of tea, cup of coffee, and going to get cozy and comfortable as we go through this really important topic. You know, something that a lot of advisors, I think, we come across, and we'll delve into it. So we've got a number of people on. I'm really, really pleased about that. So just a few more seconds, and then we'll go to our housekeeping. Thank you, everyone who is logging on right now and joining us. Before we get to meet our wonderful panelists this morning, we're going to take you through some housekeeping. You are investing your time this hour into this session, and you will get CPD points for it. An email will be sent out next week, and we'll have any links that our panelists bring up in there as well as links to their pages, so you can always continue the conversation after this session as well. If we're not able to cover questions that come up in our Q&A session, so we're leaving the last 10 to 15 minutes for that. We'll put that in that email as well. As a webinar attendee, you are on mute. We're not trying to be rude, so please communicate via the Q&A box. And we will get to introducing our panelists. We have three wonderful, passionate panelists today that see clients either very involved through the divorce process. So some are in there very much for the thick and thin of it. And then we have specialists like myself and Nikki, who's a mortgage broker and a principal of Key West Finance, that touch in at different points to help clients with their finances. Karen is a forensic accountant at BDO. Welcome, Karen.
Thanks so much, Dawn.
Yeah, and we've got Jessica O'Neill, a family law and divorce lawyer from Leach Legal. Welcome, Jessica.
Thanks, Dawn.
And Nikki, I've mentioned you at the start. We've got very interesting ways of inserting ourselves through the process of applying going through divorce. Welcome, Nikki.
Thanks, Dawn.
So I've been able to talk to each of our panelists, and they clearly show a passion for what they do because they believe in being in the corner for their clients. So I just wanted to, as an introduction to them as well, could you all just tell us what you do, especially to the divorce process and generally as well, but why you feel passionately about your role? We'll start off with Karen.
Thank you, Dawn. Yes, usually we are involved in the process in all different stages. So we can do something very simple as to just help clients know what information they have to request from the other party to help them financially settle and know exactly what assets are involved. Confirming marital assets in the asset pool is obviously one of the most important things to do. And so we can help with that. We often find there's one party that hasn't been involved in the financial side, and that party is always sort of on the back foot trying to get financial information upon separation. So we can actually help them as to what they need to ask for, and also when they get that information, just to see exactly the ownership of the entities. A lot of times I have people say, oh, I own that company. I'm a joint owner of that company. And then you go, no, actually you're not. So just to actually establish the proper shareholding of each entity involved, what assets you actually hold, but then we can get right down into the nitty-gritty complex web of structures as well. So if it's very complicated structure, we can help untangle all of that. We also do trace monies. So I've had quite a few times when a business has been sold, there's been a huge lump sum put into the bank account. usually, you know, the ones I've come across 2 or 3 years prior to separation, and then it sort of dwindled down over time. So we can usually go in and have a look at where all that money is gone. We also do reports for spending habits as well. So we've had that quite a few times where we just analyse what the money has actually been spent on. Usually 2 years prior to separation is usually what's most common. And so we can just help so that it's really to assist the lawyers, the family lawyers involved, so they can ask questions from the other party as well. So that's us in a nutshell. Oh, and passionate, why I'm passionate about it. I've actually been through the process myself, got dragged on very long time and didn't need to be. So because I'm obviously an accountant, I knew all my financial information. I knew what to look for, what to ask for. So I just really have a passion for helping those who are not in that situation and don't know what to ask for and are at a loss when everything, you know, goes to yuck. And so I just want to be able to help them so then they can settle quickly and move on. So that's always our aim, is to actually be able to help them to settle and not have a dragged out process.
And I know, talking from you as well, like you really believe this 100% in really backing up people, because you know how difficult it is.
It is.
So thank you for sharing that. What about you, Jessica? Can you tell our audience what you do and what makes you do it every day?
So what we do as family lawyers is provide clients with advice that's tailored to their circumstances. So whilst there's legislation, there's family law rules, and there's case histories that we look at in providing advice, the individual that comes to see us is often overwhelmed. They're navigating a new area they've not been involved in previously, and they need to not be overwhelmed by the advice that we provide, but rather receive advice that's tailored to their individual circumstances. That's the most helpful way of assisting our clients moving through the process. Clients can come to us before, during, or after separation, and we work with them by listening and by providing them with commercially realistic advice given regard to their own circumstances. So there's no point meeting a client who's got a negative asset pool and providing the Rolls-Royce approach, not in terms of the service provision, obviously, but by engaging all sorts of additional experts in that respect. What we want to do is help them as quickly and most effectively as we possibly can. And the reason why I'm passionate about it is the delivery of that assistance to clients. It's a traumatic time for a lot of people. It's an emotionally difficult time, and we want to provide them with comfort, information, and knowledge to assist them to move forward.
Thanks for that, Jessica. And that's coming through as a commonality between you and Karen is, let's get it wrapped up in a painless manner if that's possible, because it's difficult enough. I think definitely as financial advisors, we do pick up on that emotional strain when someone's going through that. Nikki, could you please tell me why you love what you do and how you help people?
Look, I, obviously throughout my career, sort of been in finance for over 20 years, I've seen a lot of divorce cases. So it's really important to listen, get an understanding of what their financial position is. A lot of the time, a lot of clients that I see, they haven't been in charge of their finances. It's been their partner. A lot of people don't understand, the debt position that they're in, and obviously how to move forward. So, if they're selling the marital home or one party's buying out the marital home, then, we obviously need to look at, from an affordability perspective, whether it's even possible to buy out the partner, if it's possible to move on. There's some great government initiatives now that have been brought in for single parents, that's really enabling those people that don't have a lot of equity to be able to buy a property, with as little as sort of 2% deposit. So it's, I find the best thing to do is just to listen to what they actually want to try and achieve, and we'll work out how we're actually going to do that.
Thanks for that, Nikki. Yeah, again, it's very much, it resonates with the financial planning experience where we're trying to understand what they need. And I think this is why this session came about, is because the clients trust us, and sometimes we need to reach out to other people to be able to help them complete that process of moving forward. And we've got a number of specialists that might be involved in that journey to do that. Jessica, I'm going to start off with you. I asked you this question before, and it sounds like a silly question, but I'm going to ask it anyway. How early would you like to be able to see someone when they know that they are either going to go through a separation or divorce? How early would a family lawyer or divorce lawyer be involved in that process?
Sure, thank you. So from our perspective, what we say to clients is forewarned is forearmed. So a lot of clients come to us and don't appreciate that the family court considers the financial and non-financial contributions in property settlement matters before, during, and after the relationship. And when I say after the relationship, that examination can continue all the way until trial or until a final settlement of that property dispute matter is reached. And that can occur through alternate dispute resolution as well, or via consent orders being made in the family court. But in those circumstances, what we say to people is, if you are considering separating, come to see a family lawyer so we can provide you with the tools and knowledge that you need to stand yourself in the best stead the whole way through. And the reason being is this: there's a duty of disclosure in the family court. If, for argument's sake, two parties remain in the one house and they're considering separating, what that party often has the opportunity to do is access documents and information in their home that if they were to leave the home, for argument's sake, they may no longer have the opportunity to access, which doesn't mean that the material will never be accessed, but it means it may be a more time-consuming, costly and difficult path to obtain that information. And what we seek to do in providing clients with strategies from the outset is to limit the opportunities that will limit the exacerbation of the issues that they're going to deal with as we move through the process. It also gives them the knowledge that, pursuant to that duty of disclosure, for argument's sake, their financial transactions are going to be scrutinised. So it may be the case that if they wanted to use money to obtain rental accommodation, it would be preferable to do that by cash withdrawals. But there are various ways that we structure their exit strategy from the outset. So that's why we say it's best to come to us as soon as practical.
So it's practical. So if someone is really even thinking of that, if they think that their relationship is going to break down, that's still a good time to see someone like you?
Absolutely. We really encourage people, if you're considering separating, come and get that advice. The other reason is a humanist one, and that is we don't want you lying awake at night wondering what may happen, whether you're going to be able to keep the roof over your head, whether you're going to be entitled to receive, in the case of people that may not be employed because they're caring for children, whether you're going to have means to pay your day-to-day bills, your living expenses. There's no point lying awake at night wondering about those things when we've got the information and knowledge to assist with that.
Thanks, Jessica. Karen, if to expand on that, because I know that you work closely as well with family lawyers. In terms of your experience, when does the forensic accountant come in and help with that process?
Yeah, we're at all different stages as well. Usually, if we're approached, I've had people just Google us and contact us, and then we will always get them in touch with a family lawyer so that they know exactly what Jessica was just talking about. So they know exactly what they can expect, but also so then if we end up doing some work for them, that we're actually engaged through a lawyer, so that then legal professional privilege is attached to the work that we do for them. We can come in at any stage, just give advice as to what information they need to be getting. So if they are still in the marital house and can get access to information, it's little things even such as bank statements, logging on to their internet banking and downloading every single bank statement they have access to. I can't tell you the number of times that we've been chasing up bank statements just trying to get information. And while they do have their duty to disclose, oftentimes one party does not disclose everything easily, and that's where it becomes more costly. So the earlier the better, but it doesn't mean that we're going to start doing work straight away. We can give some advice as to what they need to look at, and then they can go away and do that, talk to their family lawyer, and then if they need more assistance later, we can assist later. So we also do phased fee approaches. So when people come in and see us and need some assistance, because a lot of the times if it is post-separation, people are struggling financially, and we can do certain things, and then they can look at what we found, and then they can instruct us as to how much more they want us to do. So they're really in control of the process.
So Karen, with that as well, like people have come to you, and you've shared that in the past, and you've kind of made the observation there's a number of women coming to you.
Yes.
Because they can't use their current accountant for whatever reason, because there needs to be a separation of that. Can you tell us more about that journey of them having to not deal with their accountant, and why an accountant might choose to pick one over
the other?
Yeah,
we do get that quite often. I come across that probably 9 times out of 10. With the accountant, they obviously usually always have a joint accountant, and if there's a business or entity involved, obviously that accountant is getting their fees from that business, and usually we do come across a circumstance where they're more willing to help the person they know they're going to be getting future work from. We've had accountants saying that we have to pay for the information. So they've asked the client to actually pay to obtain financial statements, tax returns that have already been prepared in previous years and have been paid for in previous years, but just trying to get that information from them is sometimes very difficult. So that's why it's important if you're separating, to get your own independent financial advisor, an accountant, so that they're looking after you and they've got your best interests at heart. Where it does get a bit murky is if they're in the process, if they haven't finished their financial statements for the prior year, sometimes they have to stay there until that's sorted, and then they can move on and get their own independent.
Yeah, because you're saying as well, sometimes it can be difficult to get that information.
Very.
There's not a lot of transparency in the process, yeah?
No, sometimes it's very difficult to actually obtain it, even though the work was prepared previously and has been paid for, and they were clients. But it just makes it very difficult sometimes to extract that information from them. Or they can say, I sent it out. You've already been given that. And then you're sort of stuck. And if they don't have a record of that, and they haven't kept an email, or they haven't kept what was sent out to them, then you're sort of stuck with them saying, I sent it to you, but your client not actually having it. And then Jessica has to get involved and
it's almost like the
demand it be provided.
It's like you need the A team. This group of people just getting in there to help out. Thank you for that, Karen. Nikki, now from a loan perspective, right? So a number of these couples going through divorce or separation will have loans within their situation. I mean, what have you seen gone right in that scenario, and what's gone wrong when it comes down to having to deal with a loan and consolidating assets?
Yeah, I think that sort of I haven't seen a lot go wrong, because by the stage I get into, they've obviously been to see Jessica. They know, they're trying to separate the assets. So my side of that is basically, if there's going to be the sale of the property, then obviously, we need to organise the discharge. If they're transferring the property from joint parties to one single party, we need to look at, their loan application as a whole. So a lot of what I see is non-disclosure of debt. With a couple, the wife has no idea that the husband's taken out all these credit cards and personal loans and all that sort of thing. So, I see that a lot. But yeah, as far as the loan process is concerned, I probably come in at in the middle stage. Once they've got their legal advice, once they've figured out what assets are actually on the table, and then it's a matter of, preparing that application.
Thanks for that, Nikki. We are going to definitely loop back to you around the rebuild, because I know you've got a number of things. Actually, I think about how different people come in at different points in there, and you come in really when they've got a chance to look forward again and helping to build those steps. So we'll link back to you around the rebuild stage. Jessica, coming back to you around what you've seen, because we're talking with Karen in the past. She said that different skill sets are needed from the family lawyer depending on how ugly it's become. Can you share that with us? Because we know it's good when it's amicable and people are on the same page. And if it's not, how can that change the process?
You really need to remain mindful, I believe, at all times of why you became a family lawyer, and that's to assist clients. And assisting clients, as I touched on before, pertains to understanding what their needs are, and developing your case strategy and your matter strategy around the needs of that particular individual. So a high conflict case, or a case where there's domestic violence associated with it, or allegations that may not even be proven, it's not going to necessarily assist if you're acting for a party and adopting a particularly aggressive approach. Not only is it not going to help the clients by perpetuating the conflict, in the circumstances where that matter may end up in the court is not going to take a particularly favourable view of that approach. We don't seek to exacerbate the conflict for clients. We seek to achieve resolution. And often we find the reason the clients haven't been able to resolve their matter between them is because the emotional element. We try to understand that aspect for clients, because obviously it's an incredibly difficult time, but we try to remove it and focus on what would be a just and equitable settlement for those people, and to help them with that. And certainly, just touching back on what you just spoke to Nikki about, from my perspective, if I'm acting for a mum who's come in to see us and says, I really want to keep the home, I just don't know if it's going to be possible, we try to bring in people like Nikki very early on in the process, because you want to keep things realistic for your client. So if it's the case that my client's never going to have the means or the borrowing capacity to refinance, we want to start reality checking and testing that to best assist that client from the outset, rather than get all the way through a settlement and then have the client absolutely devastated because there's a for sale sign out the front of their home.
Yeah, so it's really setting the realistic expectations. It seems that it's always a delicate balance that you're trying to achieve through the process, because it can be highly emotional, and you're trying to weave in a sense of rationality through it, which can be quite difficult to do as well. And we'll definitely touch on that, because Karen's brought up some previous points around that, which I'll expand about soon. Jessica, you told me as well, with domestic abuse that's happening in there, you bring in other specialists to assist with that. What does that look like?
What it looks like is, from my perspective, I need to look out for my clients. There is legislation, as I touched on previously, there's the Act and there's the rules, but family law undeniably is a humanist form of law. And I say that because you cannot help these people without looking out for their well-being for various reasons. A client can leave my office and feel unsafe at home, and we can't have that. But I'm the person that has the knowledge and the information and the strategies, like other family lawyers, to assist them to feel secure at home, because we've got tools that we can inform them about, but also the mental health side of things. Now, going through a separation is an arduous process, regardless of whether you achieve a settlement in 2 months' time or 2 years' time. We need clients to have the best mental health, to be best prepared to get through that process, however long it may take. And in domestic violence, cases of domestic violence, we have ways of triaging the matter. In circumstances where alternative dispute resolution, they actually screen for domestic violence. And family lawyers, the longer that they've been in practice, tend to have greater understanding of the warning signs that may give rise to allegations or evidence of a history of family violence, because it's not the case that clients will come to you, even when asked in a first appointment, and necessarily disclose that. So there are things that the astute family lawyer will look for, and as the relationship of trust and confidence builds, hopefully the client will feel comfortable enough to disclose it. But if they don't, it's our responsibility to make sure that we take steps to best deal with that when it's our concern.
Wow, that is powerful work, Jessica. It's really powerful work. So I mean, I know that my client is going through that process and they are being protected that way. That will give me a lot of peace of mind as being a financial advisor, because for us as financial advisors, we are really our clients' advocates. And having the right kind of specialist going through that process with them, you feel good that they're in safe hands as well.
Yeah, and certainly from my perspective, I'll talk to clients about the grief cycle and what they may be experiencing, but I'll also speak to them about mental health. In that, from my perspective, the stigma around mental health difficulties is a lot less than it used to be. But what I say to clients is getting treatment for mental health is actually a very responsible thing to do. It's just like if you cut your knee, you'd think nothing of putting a Band-Aid on it. Asking for help and support around this time is really, really important. And we speak to them about the resources they can use. For example, going to see their GP and getting a mental health care plan so they can have some subsidised counselling and assistance through this process.
Oh, thanks for that, Jessica. So Karen, I want you to kind of, if you could expand on that, because you've shared with me that you said a lot of your job is trying to remove the emotional, because it's the emotional process to it. Like you said, you can go through statements and they can see what has been bought for the girlfriend, and you're trying to keep people on
track.
On track. Can you just tell us from your perspective, what that looks like?
Yeah, usually the first meeting that I will have with a client, it's very emotional. And you're right. So if they've not really taken much interest in the finances before, and then they've started to look at them post-separation or leading up to separation, and they found a lot of things like, the Tiffany ring that the girlfriend's been bought, or even a house or townhouse that they've actually bought that they go or put a deposit on that they are intending to move out, that type of thing, and the spending habits around hotels, restaurants, all that type of thing is all highlighted in your bank statements, credit card statements. So once those come forward and they can see them, sometimes they find it hard to get past that expenditure. And so I just sort of have to put that in a little box to the side. And if we're actually looking at expenditure, I just say, that's fine. I've categorized that under jewelry and Tiffany's, and it's sitting right there and it's not going anywhere. But let's focus on the big picture and let's look at the facts, the finances, so that they have all the facts so that they can financially settle with the knowledge that they're doing it with the entire assets of the asset pool, and they know that they're going to get a fair settlement. And so you just always try and put that emotion to the side, but you don't get rid of it. You just put it in a little box over there. It's still there. You can still question. Your lawyer can still question them about it, but it's not our main focus.
And so going to kind of paint the picture further of what you do, what kind of clients actually fit into that box? Because you're saying that you're going through all of this and you're doing the investigation piece, but maybe not everybody would need a forensic accountant. You're saying that it's specifically when someone doesn't understand the structures and the finances that they have, right?
Yes, that's right. So a lot of the time we get people who don't know the structure of the business or the entities that are involved. So we will actually find that out for them and go through that process so they know exactly their entity structures, what's involved, what income is coming into that entity structure, where it's actually gone, that income, and there's often inter-entity transfers as well. So we really look at that for them so they understand that. But just so, and it can be as simple as doing that for them, or we have other ones where we've actually had to trace payments. So there's been a large sale of a business 2 or 3 years previously. There's been millions of dollars put into that joint account, and all of a sudden there's not much in there anymore. And so then we go back through and check where it's all gone. Sometimes, obviously, we can't say that's their personal bank account and it's gone to them because we don't have access to ask for their bank accounts, but we can definitely say which bank account it was put into as per the bank statements, and then it's up to the family lawyer to be questioning where's that and disclose that information. And asking for that will then often lead to where it ended up.
Well, you know, your job seems so interesting, Karen, and it's really like the Sherlock Holmes of the accounting world. How does social media, because you and Jessica both mentioned social media when I talked to you before this session, how does social media tie into your process?
I'm not going to lie, I do a bit of a Facebook, Instagram stalk when I get new clients, because it does give you quite a bit of information. So we do just have a quick look, see if there's anything that sort of red flags, and then we know maybe what to concentrate on a little bit more. But overseas holidays, etc. A lot of people don't realise they really should have their privacy settings a bit stricter on social media. It's fine, just keep it how it is, it helps us. But it's just trying to gauge, you know, I was away for business, and then you can see, well, not so much. But it's not a huge part of it, but we do just have a quick look at the beginning to see if there's anything we need to see. But I'm sure there would be a lot more that Jessica probably
so
looked
Jessica,
at.
You do brief your clients a bit on social media. I think you're saying about social media usage past the point that they come and see you. What's usually your advice to them? What needs to be considered at that point?
My advice to clients is, I don't want you to say anything, do anything, or post anything that you wouldn't be happy to have printed on the front page of the newspaper, because I guarantee you, if we're going to find it, the other side will find it. And what we're trying to do is work towards a resolution. Any steps or behaviour that you take that may inflame the situation is only going to lead to further headaches from you and take you a step further away from achieving that resolution. So if you're coming to see myself, you're spending money on legal fees, let's get it resolved. Let's do what we can to help you. You're seeking advice to help you. Take that advice on board. Stay off social media for a while. Tone it all right down and just stick on your best behaviour.
That sounds like good advice. You would think that might be a common sense approach, but I can understand when the emotional overrides what you're supposed to be doing rationally. You're there to remind your client what's best for them. And that kind of leads me to the point, Jessica, around, you know, we see people at separation and divorce, but there's also a way to kind of minimize that chaos when that happens, because I think now the rate is about 47%. We're talking about financial agreements here, right? So financial advisors will talk a lot about estate planning. We want them to be looked after from an estate planning point of view. Why is it so important to get a financial agreement? You know, is that the best expression of love?
That's a two-part question, I guess you would say. According to Karen, some of her clients would say that Tiffany's ring's the best expression of love, but that may not be helpful. So in terms of the importance of a binding financial agreement, they can be entered before, during, or after a relationship. The reason why, certainly for people that come to see you, Dawn, or anyone that's watching today, the reason why we would consider it important, if you've got a client coming to you, and they've obviously got an awareness about the need to perform a financial health check. They've no doubt got insurance on their house or on their motor vehicle or anything like that. Choosing to enter into a binding financial agreement is another form of health check, and it's another form of insurance. We all know that there are cases out there where binding financial agreements have been successfully overturned, but it's an insurance policy in essence. If you're not going to need a binding financial agreement, terrific, but unfortunately, none of us ever have a crystal ball. And whilst we enter into relationships with all of the best intentions, sometimes years down the track, for whatever reason, the relationship proves not to be successful. It's in your best interest to know that you've taken steps to protect yourself, but not only to protect yourself, but to minimize the amount of conflict that you experience in exiting that relationship. If you both agree to uphold the provisions of that binding financial agreement, terrific. If not, you've still got it as a backstop.
It's just funny it's just starting the conversation early enough, because I did see a presentation about that, and I actually had a conversation to my kids about it. So while that was not part of my process growing up, but I kind of went, that makes sense. I think if it's introduced early enough as a concept, it's not such a surprise in a relationship because you're kind of talking about it at the outset. So maybe we should introduce it in the curriculum for primary schools, I think, if we...
Well, but what we see in family law matters so often is that communication broke down.
Yeah.
So for whatever reason, if it's the case that you want to start a new relationship or enter a new relationship and you're going to give it its absolute best shot, it's just part of the process of communication. Make it an open discussion from day one, maybe day two, but from day one. And that way there's no surprises. There's no 2 years down the track and you're going to move in together and someone gets a document shoved under their nose. That's going to invariably cause a hiccup, a difficulty, or the end of the relationship. If it's part of a open, ongoing discussion, not only are you going to limit yourself to a subsequent application that there was any duress involved, but you're also going to best navigate what I understand is a difficult conversation with a partner.
Yeah, and you know, that makes sense. You know, like it does make sense. And sometimes you kind of go, it's too late. By the time communication breaks down and introducing that, because you're saying it can be done before, during, or after. But we're also seeing as financial advisors this interesting thing where, you know, retirees are gifting money to their children for a house to pay down debt. And then they're kind of concerned, or what if their kids separate, right? So in those circumstances with those retirees, how can they be protected by something that is kind of out of their hands, their kids' relationship?
Obviously, we hope that none of our children ever go through a family law settlement. But if a retiree or anyone is considering advancing a sum of money to their child or children, what they need to do is take advice from a family lawyer about how best to advance those funds. The reason being, if they are to gift the money, that's going to be treated very differently to a loan. And the different categorizations and treatments we have, often in the family court, often comes down to a question of judicial determination, because one party will say, no, that was given to us, and the other will say it's a loan. And how best to protect yourself by establishing or demonstrating that you've loaned those funds to a child of yours comes down to the existence of credible paperwork. And for argument's sake, a loan agreement, interest doesn't necessarily have to be payable, but there needs to be clearly articulated terms and a paper trail, correspondence with the child and his or her partner in relation to the purpose of the funds being advanced, the reason and the expectation around those monies either being repaid or gifted. Yeah.
Again, so it's another form of insurance in a way, because I think we see that. We see clients coming with it, and we know that this is happening. And I think, you know, the lesson is we need to kind of take it a bit further and make sure those agreements are in place, because they will be protected. Because it's a circumstance, it's out of their hands, what's happening to their children's relationships. Thanks for that, Jessica. Nikki, you've been so patient there, because I know that you've got so much to share with the rebuilding. Someone coming out of divorce, going from, you know, dual income to single income. And you just said that there's such a range of how that could look like, depending, because some people can qualify for 30-year loans, some people can't, depends on what age. Could you take us through that?
Yeah, so the banks call that an exit strategy. So when a bank looks at an application, they look at, okay, what type of employment they have. So for example, if you've got a bricklayer who's going through a divorce at aged 50, the expectation is that he's not going to be able to continue to lay bricks until the age of, 70. Whereas, if you had a 50-year-old professional, you would expect that they potentially, could, carry that loan for a longer period of time. For young families, so if you've got a the wife's just gone back to the employment, gone back to employment rather. Does she have super? They look at that as an exit strategy. If they don't have any super, do they have the potential to work for 30 years to be able to repay that loan? So there's lots of different factors. Exit strategy is a massive focus at the moment. So, and that's where we obviously, we would obviously come to a group of financial advisors and ask for, okay, what does their exit strategy look like? How are they going to repay this debt, before they retire? So whether that be from super, sale of assets, downsizing, they're all acceptable exit strategies. If you've got a client that's got an owner-occupied property as well as an investment property, well, then the investment property would be the exit strategy. The sale of that would clear the owner-occupied debt. But a lot of it is definitely based on occupation, term of loan, age, asset position.
Yeah, so you mentioned before that you've had a professional that had retired, still managed to get a 30-year loan on the investment properties.
Yes, as an 82-year-old retired dentist that had a very, very good exit strategy. The debt was all investment debt. So they owned their own occupied property. They had a holiday home. We're talking about obviously a very asset-rich couple. But at that point, they didn't want to draw, they didn't want to sell their shares. They didn't want to sell the investment properties. They were asset rich, but not income rich. So, we put forward the application, the loan serviced based on their allocated pension, so we got that across the line for a 30-year term. It was a short-term exit strategy. They had intentions, they were waiting for the market to pick up. They wanted to sell those assets within, sort of a 3 to 5 year time frame. But to service a loan over 3 and 5 years would be extremely difficult to prove. Excuse me. Based on what their actual income was at that time. So, yeah, everything was accepted by the lender. And there are lenders that do look at exit strategy quite differently to others. A lot are very risk adverse, whereas others, seem to have a little, a bit of a better take on it. So,
okay, so you've got the ones that can demonstrate that. You've also said that the new introduction of help for single parents. Can you tell us more about that as well?
Yeah, so it's a government initiative. It's called the Family Home Guarantee. It is only for single parents and must have a dependent. They have to show that they are actually physically divorced and not in a de facto relationship. The government's released 2,500 scheme places for the next 4 years. What that enables them to do is to enter the property market with very little deposit. So, the government will guarantee the 18% deposit that would normally be required. So basically 2% deposit would be required, by the client. The government actually guarantees the loan rather than the bank charging what's called lender's mortgage insurance. So normally if you borrowed any person borrowed over 80% of the value of their property, they would normally pay lender's mortgage insurance. So with the government initiative, they cover that loan, so they actually physically guarantee it. So there's no mortgage insurance, which can save, tens of thousands of dollars. So, but it's a fantastic scheme to allow, especially single parents with very little deposit to get into the housing market.
Oh, thanks for that. At least I know that there's a range of options that are available. So it's just like you said, you go to the right specialist, they're going to be able to have the information to present to actually help them through that. So again, that sense that whenever working alone, financial advisors kind of project manage through it. Sounds like how Jessica does that as well, project manage through, get the right people in at the right time. And definitely that would be, I think it's good to hear that a good mortgage broker will have different options available depending on where they are in their life. So thank you for that, Nikki. I can say that, our Q&A chat box is just like, it's on fire at the moment. So I'm going to wrap up with this bit there so we can at least get to some of the questions. And just sort of lastly, for all of you, and we'll start with Nikki, is how can a financial advisor find the right fit for a specialist like you? So, what would they be looking out for? But also, how do you best like working with a financial advisor through the process?
Yeah, look, the two work, in synchronized form. I mean, I can't do my job, without you guys. So I think the important thing is to find, if you don't have a finance broker or mortgage broker that you work with, I think it's important to find someone that's got experience, that can gel with your clients. All clients are different. You would look at a client and go, well, that person might prefer a male advisor, or, one person might prefer a female advisor. So I think it's important to just get a feel for your clients and, look for the best fit, of who could look after them the best.
Thanks, Nikki. What about you, Karen?
Yeah, I think we spoke briefly yesterday about the dream, what you want and how you get there.
Yeah.
So I think it's really important to have your financial advisor in place while you're going through the process, so that, while you might not get there in the next 2 months, 6 months, 2 years, what you're actually aiming for, and you can help through the process of how to actually get there after you finally do settle and you can move on. But then you may still need some more advice after that, so that your end goal is your end goal, and you just help in the process how to get there the whole way through. So sort of before, during, after.
Yeah. And then how would they, if let's say a financial advisor doesn't know a trusted forensic accountant, because they're building on this to improve their process around helping people with going through divorce, how would you say is the best way to find the right fit, if you're trying to approach an accountant?
Yeah, I think the way to get the best fit is, again, it's a personal preference, and if people understand the process that you're going through, it's very difficult to explain to people if you haven't been involved in it yourself. You don't understand all the things that can happen. How it should be and how it usually is are two different things. So I think someone who actually understands that process, but also who your client feels comfortable with, is probably the most important. And their needs obviously always come first. So that's what the advisor has to be focused on.
Thanks for that, Karen. What about you, Jessica?
From my perspective, what I consider to be really important is that the client feels confident in the individual, and that comes about in a number of ways. Obviously, there's the personal referral aspect. If they know someone that's had hands-on experience with that person, that's going to be really terrific. It's feeling confident in the advice they're receiving from their financial advisor as to the merits of this person. And that can be established in a number of different ways. Arrange a coffee, reach out to the lawyer to build a professional network. Obviously, like any other professional, the lawyer is going to want to get paid when meeting with the client. But if you want to build your own personal networks, get in touch with a lawyer. It may have more benefits than you know, in that the lawyer may need some financial advice themselves. And the other aspect is you can always contact the Law Society in each state for recommendations. But fundamentally, from my perspective, if you've got a client going through a particular legal matter, in this case, a family law matter, if you had a client going through with a particular medical issue, you would seek specialist advice and treatment. It's no different in family law. A specialist family law firm or specialist family lawyer can assist your client by providing the most direct, specialised and concentrated advice relevant to that particular person. And that's going to be effective for a number of reasons, not only helping them to resolve their issue, but they're going to appreciate that you've established that connection for them.
Oh, thank you all. And I'm going to jump straight into the questions. I think I could talk to all three of you for a very, very long time, but we've now got about 10 minutes to cover a number of these questions. And again, if we don't cover them, we'll try and get them answered via email when we send out our email in a week's time. So Joshua has asked this question, and I'm assuming it could either be for Karen or for Jessica. How often do people come to you later than what is ideal due to financial constraints or an uncooperative partner? If this is common, what are some of the solutions around that? I suppose maybe speaking from a perspective of a financial advisor, what can we do if they're not getting there soon enough?
I have been on the back foot in a couple of cases where I've been contacted, a month before trial. It's probably a little bit too late. We can help as much as we can, but really the earlier the better, obviously. With cost constraints, I think I spoke about that before, and it's a very common one. So a lot of the time we do phased work so that we always take into account what the client can afford and what they can't afford. Sometimes they do have financial constraints because the other party is not supporting through the process, and sometimes that's something that happens to try and get them to settle earlier and probably not as fair as what it should be. So we always try to help as much as we can, and it is very difficult. I know a number of the people that I've worked with have actually got loans from their family to help them assist them through the process. It's very difficult because if you spend a little bit on the expertise, it will help you in the long run, but it's trying to get you there in the middle. And I suppose that's where you would come into, Dawn, as to how they can get there.
Okay. Jessica, do you have anything to add to that?
Yeah, from my perspective, when a client comes to us late in the piece, the most important thing we can do is clearly communicate to them the limitations they have and what we can and can't assist them with. In terms of financial constraints, it is possible to bring applications in the family court for what we call litigation funding. So there are lending agencies out there, but there is actually a capacity for the family court to make an order, for argument's sake, for one party to pay for every dollar he pays to his lawyers, one to the other side. So there are different tools and strategies we have to assist to overcome those limitations.
I've got another question here as well that might be more for you, Jessica. Deborah has heard that parental wills sometimes come into play in children's divorce matters if they're likely to inherit a large estate in the future. Is this normal?
In terms of normal, the position is with a tricky one. What happens is before someone passes away or loses capacity, they've got the discretion to change their will at any time.
Okay.
Until someone passes away and that estate comes into being, an expectation to receive something under the will is a mere expectancy. It's not a guaranteed inheritance. The way the family court may treat that will depend on the evidence of the parties as to what the understanding was during the relationship. And it will also depend on whether that will is disclosed. And in any event, if the will is disclosed, the court's more likely to treat it as a financial resource rather than an asset, which is not financial resource. We tend to say to people, it's not a tangible asset in that it's not a house on your side of the ledger. It's something that you may have the benefit of down the track or in due course. So it's not a black and white area of law by any means. And so that's really one of the reasons as well why the family court deals with these things on a case-by-case basis.
Okay. Next question. Like I said, there's a number of them. This might be for Jessica, for you, and for Karen. So just hop in there. separation of assets, Natalie has asked this. There's no calculator that helps understand how the split comes about. It seems to come down to negotiation tactics, and sometimes there isn't a fair split. Is there any progress in Australia to protect women who aren't able to afford legal and accounting fees to get a fair outcome? I suppose I think that's the sense of the question.
Sure. So if a person is to represent themselves in proceedings in the family court has a self-represented litigants handbook that they must ensure that individuals received. There's an inbuilt check and balance in the legislation for how a property settlement is determined. And that is that the family court can't actually make orders for the adjustment of parties' property interests unless the court itself is satisfied that they're just and equitable. So what that means is the overall outcome, once the court and family lawyers, whether by mediation or through a contested judicial hearing, have heard all the evidence and determined what the position is going to be, needs to be comfortable that it falls within a range of outcomes that, given regard to the circumstances of that case, in particular, all the ins and outs, is just and equitable. So yes, there is a check and balance, because if the court is not satisfied with an agreement that the parties themselves have reached, it will decline to make the orders or issue a requisition for more information.
Thank you, Jessica. Karen, do you have anything to add to that one?
No, just mainly due to that's why it's so important that you actually do know exactly what entities are involved, and what the other party, what shareholdings, directorships, trusts are in play as well, might not just be in their individual name, so that the court then can make a decision that it's fair and equitable.
Thank you. Karen, so Louise Parker has said she needs your details ASAP. So Louise, I think if you Google a video, Karen Lander, you'll be able to find her. If I can't get those details, I think it's just sparking a lot, right? Like for us, we see a lot of clients, and there's some things that are quite urgent because we definitely care about getting outcomes for those clients. If I'm just looking through the questions, sorry guys, if I can't get to everything. Bruce has made the comment that as a financial advisor, how do you choose, which client to continue to act for when you've built a bond from both of them? So I suppose maybe like Nikki and Karen, I know Nikki, you said you've had like amicable divorces that you've gone through, so you've been able to help both. Karen, how would an accountant, or how would you choose if you're close to clients, how would you choose which one to continue helping, and then what would you do if we look at it from an accountant perspective?
Yeah, because I'm on the forensic side, I only ever get one side, so it makes it easy for me. But with tax accountants, etc., I'm thinking that they would really need to sit down with both parties and have an actual discussion and communicate what's going to happen from there. I think it's really difficult to decide who you've had, got the better relationship with. It is a bit tricky, but I think it needs to be communicated clearly to both parties, so then they can, move on and get their own accountant if need be. But when it comes to me, I'm definitely usually looking at one side and assisting. We're looking for the facts, but we're always usually working for one party to help them.
Okay, and I guess it is a hard one for a financial advisor to pick, but I think that's why as well we've got a community of advisors that we trust as well. So if we have to refer out and work with someone else, I think we know people that we would trust for that, and we know the best batch for those clients as well. So I think that key point of communicate with them, be on the same page.
And I think also if it's amicable, you could actually keep working for both. I think it's only when you run into problems where it's not so amicable that it gets a bit murky.
Yep. So Nikki, in your case, when it's amicable, you're able to kind of help them through the process together, isn't it?
Yeah, definitely. The ones I have assisted, they've already got their financial binding agreement in place. It's been prepared by their lawyers. They're quite, they're on top of it. I don't disclose, information about their finances to each other, but to get the process you know, started, you know, the discharge paperwork signed. Obviously, you know, it's normally one person buying out the other, so it's in their best interest that their finance go through so they can wipe their hands of it. So yeah, the majority of the time, you know, they've reached that point of, you know, they've negotiated, they've written their consent orders or their financial binding agreements in place, and yeah, it's quite smooth.
Thank you again, our panelists. It's now right on 10, so we've got to wrap it up there. I think, again, this conversation could have gone on, and we've got unanswered questions, so we'll try and attend to those. Please also reach out to the panelists directly as well, Karen, Jessica, and Nikki, if you've got further questions or want to pick their brain further as well. And thank you everyone who joined us today and also participated in this conversation. I think all of us deeply, deeply care for our clients, and we want them to get the best outcome in something that can be really quite emotional for them. So thank you everyone on there. Have a good week and keep on fighting the good fight.
Thank you.
Thank you very much, Dawn. Thanks.
Thanks.
See ya.